أعوذ بالله من الشيطان الرجيم ولتكن منكم أمة يدعون إلى الخير ويأمرون بالمعروف وينهون عن المنكر وأولئك هم المفلحون.
There are some questions that you've posed. And the question really is, do the local authority have a point when it comes to safeguarding and when it comes to naming body parts? If I can stay on that for instance, because let's face it, Shaykh Shams said it beautifully. Actually, and majority of us parents do not object to the DFE guidance, and we know as parents that our children will see same-sex couples outside. We know as parents that our kids will be at some stage knowing the names of their private parts. It is at what stage and at what age we, they get to know those names. The question really is, does naming the body parts, or does knowing the naming body parts prevent abuse? And that's the question. Now, I know I asked Danny Hassel, whether he knows of any cases where prosecution has stopped because somebody couldn't name their body part. Now, I'm going to ask my very good friend Shaun, who both as a prosecutor, and he prosecutes some of the gravest murders and manslaughters and rapes and sexual abuses, and defends. And also on the Children Act side, he looks at public law cases where children are being removed from parents, and the local authority are moving them because of abuse. Shaun, if I can ask you, my friend, at the age of 5 or 6, or at any age, as a prosecutor, if a child is not aware of his body part, i.e. cannot say the word vagina or penis, will you as a prosecutor drop the case? Shaun.
Okay. Thank you, Mizan. Good question. The long and short of it is, I'm relying very much on experience of different cases over the years, and I have seen a great movement in the last 2 decades in terms of trying to create a situation where it's easier and fairer for children to be able to communicate, which is the key, when they have suffered abuse or where they may have suffered abuse. So to answer Mizan's question, I have not come across a case where a prosecution has not been able to advance because of simply a name not being said, or the wrong terminology being applied, because it's much more holistic, it's much more complicated than that. The real issue that the criminal justice system and the family law courts have looked at, and in my opinion, there has been a great deal of positive movement, is the idea that we don't, as a local authority or as lawyers or as adults, expect children of 5 or 6 to speak the same language and use the same vocabulary as us, because they're children. And children, of course, have different needs. Children of different ages from different backgrounds may have, all sorts of different capacities. And the whole idea and the movement that we've reached at the moment, which has avoided, I think, the real problems that there were in the past, which were not about not being able to name body parts. It was being able to have a situation where children felt able to communicate. And it seems that what I've noticed the change has been is that now, instead of children having to adapt to us as adults or to lawyers and speak our language, we have to adapt to them. Now, safeguarding issues, therefore, I am extremely interested in safeguarding issues because they touch upon the work that I do, but I don't really deal with, for example, the public law elements of the relationship between the community, parents, and schools. I deal with the aftermath. I deal with the sharp end of the situations that most of us hopefully never have to experience, which is going to court. And again, perhaps it's a long-winded way of answering Ms. Ann's question, is that the problems that arise in relation to getting evidence from children arise from creating a situation where they feel safe to communicate. And things have been put in place in terms of interviewing children, having people who are specially trained that make it easier for them. What I certainly have seen over the years, which varies, but is an important issue, in terms of family law, local authorities, social workers working with families in order to improve safeguarding or an awareness of safeguarding, is again, what's very important is establishing some, not just communication, but some partnership. And I note that the NSPCC, if one looks at what they call the pillars of their approach to safeguarding, and it's sort of published on their website, and it's something that they use as a starting point in terms of implementing policies, are a number of principles such as empowerment, prevention, proportionality, protection, partnership, accountability. Now, some of those won't directly affect us as civilians, as parents, but some really do. And that issue of partnership is really important, because I've seen cases over the years, many cases, where parents who are in a situation where they're working with social services because there have been problems, when there isn't a trust and there isn't proper communication, it is so much harder then really to implement the safeguarding that every child deserves and every family deserves. If you have parents, for example, who are not at home singing from the same hymn sheet, using the same principles as the school, there's going to be a clash. And what I would say in terms, for example, of the issue about, well, prosecutions, have there been prosecutions, or is it likely that prosecutions will fail because simply of a child being unable to name a body part? For years, in family cases and in criminal cases, there are children who have particular needs. Some have needs that are very marked. They may be autistic. They may not just be on autistic spectrum, they may have learning disabilities. And I think we as a society have moved, prosecuting authorities have moved forward to be able to adapt so that we're dealing with a diversity where we are not assuming that children from a particular background will always communicate in the same way. As I said, it's about in my view and in my experience, opening up the communication. And I suppose really the question we're looking at is what are we trying to achieve in safeguarding? One of the things we're trying to achieve is to prevent abuse, but also to allow disclosures, to listen to a child's voice, for the child to communicate. I think the way that we do that is by engaging the trust of the parents and by listening to the children, not imposing on a 5-year-old or 7-year-old or 8-year-old rules and language which actually don't go to the heart of the issue. So it's about respecting communication and encouraging the communication of the children. So that is perhaps an overview of the experience that I've seen over maybe 2 decades now of the change in what I think is a less paternalistic approach in the family criminal courts, to a situation where we listen more to children rather than imposing rules upon them. So,
Sure,
Ms. I hope that touches upon.
I'm grateful. Shaun, we've both dealt in matters, and I'm sure you would agree, there are times when adults, grown adults, who have been abused either in their young age or very recently. Sorry to take time, but there was a story shared by Honourable Judge Plumstead about a young lady who was on the stand, and maybe you remember this because it's quite widely shared at the bar. The victim could not use the term vagina from the witness box, and she had to write it down because she was embarrassed. This was a young lady giving evidence from the witness box. And I'm sure you've met and you've seen, whether it's a special needs child, whether it's a grown adult, that in certain places, in certain circumstances, they're embarrassed to name their body parts. And because they're embarrassed to say it, it has not stopped prosecution, whether it's in the family courts or in the criminal courts. Would you not agree?
Absolutely. I mean, there are different ways of communicating. The question is, if a child is going to be making disclosures for safeguarding, are they able to communicate in a way that we understand? Similarly, in court, is the witness able, and is the court procedure allowing them to communicate in the clearest way possible so that we understand what they are saying? And in the same way as with some children, and again, this is I've seen this in family courts and criminal courts, right from the start of my career, been very used to situations where a witness will be asked to look at a body map, which is just simply a drawing of non-gender specific. It simply shows the areas of the body. In fact, it's what GPs use to make notes of where injuries are, accidental or non-accidental. And that's a perfectly good way, when appropriate, of finding out exactly where the injury took place or where the touching took place according to the witness. So really, it's about adapting. And we as a society, and therefore the courts and the local authorities and the social workers, being able to adapt so that the witnesses who are vulnerable because of age or learning difficulties or for whatever reason are best able to communicate. So really, it's a question of not being rigid and just assuming that we should treat everybody the same. You know, and that goes even beyond important things such as the protected characteristics of religion and other aspects. So absolutely, I think in fact, as Ms. Ain, you say, that's something that has been implemented in the family and criminal courts for at least 2 decades. It's nothing new, and it hasn't prevented prosecutions from taking place, or in fact, local authorities been able to conduct care proceedings where the welfare of the child is the primary factor in the proceedings.
And Shaun, one last point. I know our audience is predominantly Muslim, but where there are issues of, and going back to naming of the body parts, even where a child is aware of body parts and knows how to name them, does that naming it prevent them from being abused? Isn't it the question, like you say, it is giving the child, empowering the child to be confident so he or she can talk to mum, dad, or any other member of the community that he or she trusts, for example, schools, teachers, etc.
Absolutely, because I practice in family and crime, which are two areas of law that have very different purposes. The criminal court is about punishment, it's about gaining evidence to see whether or not someone has committed an offence, whereas family is about really ensuring the welfare and safety of children. But certainly the key is always, I think, to look beyond the specific issues and the specific rules and think what is actually the purpose. And one of the purposes of safeguarding is to either prevent or to stop. And if that is about listening to what the children say and having accurate information from them, it's about having a situation that best allows them to communicate. And I know research and practice, certainly in family law, has shown that if a child is in a situation where he or she has a relationship with their parents or with people they can trust who are adults, then they are more likely to be able to then make a disclosure when they're suffering harm, as opposed to sadly cases where children say nothing because they feel afraid to. So that's not really, it's not about the terminology, it's about having a safe area or channel of communication. And I think that can sometimes be lost when one focuses on just mechanically whether or not the right word or the right form is made. But children react in different ways. They're growing and developing in different ways. And as I mentioned before, I think it's about us adapting to their needs and making sure that they're comfortable. That is much more important, in my view, than any specific terminology or vocabulary.
I'm grateful, Shaun. interaction with Danny Hassel, I think he said to me that prosecutions stop because they don't name body parts. So you and I can both say that's a lot of nonsense. I want to move.
Well,
to
it's not. It's not been my experience in 20 or 3 years, and I haven't heard of that from the people I work with. In other words, the other barristers in family and crime. So if that does happen, then it is, I think statistically, it'll be interesting to see how frequently that has actually materialized.
Study, darling. I mean, in the meeting.
Not very much.
Not very much. Thank you very much. I'm just going to ask Shaun a question. Shaun, there are a number of questions that are popping up in terms of parents being prosecuted and parents being asked various questions in terms of being reported to prevent and etc., which is a threat. As a prosecutor, when you see a charge that isn't fully made out, what is your duty as a prosecutor by law?
Well, I mean, your duty as a prosecutor, I mean, of course, a prosecutor could be me as prosecution counsel, which is when the case is up and running and has reached a court or is about to reach the criminal court. But in fact, the other prosecutor on any case is going to be the CPS lawyer who deals with a case right at the very start. So although I sometimes will be brought in or counsel will be brought in, for most cases, you will have a referral from the police. The police then contact CPS. And at the first stage, there's a threshold test, which is whether there are reasonable grounds or there's reasonable evidence for them to charge somebody. And once that charge has taken place, then you move to the next stage, which is when things go to court. And in terms of whether a case is strong enough or it continues, basically what you shouldn't do as a prosecutor is simply form your own view that, well, if I were on a jury, this would work, that wouldn't work. There needs to be consistency, and the consistency comes from the Prosecution of Offences Act, where there's a two-stage test where the CPS lawyer or I at a later stage will have to look and say, is there a reasonable prospect of conviction? Which means, is there enough evidence upon which a jury, applying the right principles, could find somebody guilty? Because of course, in any particular case, if there's enough evidence, you may have jurors that have a particular view and may agree or disagree. Quite frankly, you may have cases where in one part of the country, just because of the configuration of the 12 people you found, you may be found guilty or not guilty, depending on that. But the prosecutor has to be the filter who says, is there a reasonable prospect of a conviction? The second test is it in the public interest? And I think in most cases, that's easy. If it's a case, for example, of a child or somebody suffering harm, then it's obviously in our interest as a society for that to continue. There may be some cases where, for example, you may decide not to, it's not in the public interest. If for example, you have a victim of a sexual offence who is 13, the defendant is 14, they both have marked welfare needs, the question would be, well, do you need to prosecute? And that would depend on the individual circumstances. So it's a two-stage test. Is there enough evidence, and is it in the public interest? And that is a statutory duty. That's the Prosecution of Offences Act 1985. So in theory, every single prosecutor should bear that in mind, but also at regular stages throughout the case, because it may well be that a case seems to have strong enough evidence, but as time goes on, the victim or alleged victim, for example, may provide another statement and say, I'm not really sure, I'm not quite so clear about it. So we have to, as prosecuting authority, as prosecuting agents, make sure that every stage we apply that test to avoid there being miscarriages of justice.
I'm grateful for that. Shaun, I think that clearly shows just because somebody threatens us with some sort of an exposure or prosecution, it is not just up to them. There is safeguarding put in place that malicious prosecution doesn't take place. And of course, if it does, there can be inquiries into why that's taking place.